Kimball, a partner at Holland & Hart in our Salt Lake City office. I know that everybody has busy schedules, and so to make sure that we can get through all of the material within the hour allotted to us, we're going to go ahead and get started. Today we'll be discussing unique compliance concerns applicable specifically to Utah, so under Utah law. If you have joined some of our other health law webinars that we've been doing as part of our kind of healthcare compliance boot camp, you'll know that most of those are applicable. You know, we're going through issues at the federal level that are applicable to everybody. And then we have these breakout seminars where we're covering issues applicable to the states within our footprint, you know, mostly within the Rocky Mountain region. So thank you for joining today's webinar, again, that's specific to Utah. I will be presenting today, as well as Blaine Bernard, who's also an attorney in our Salt Lake City office. Both of us practice in the healthcare space, and Blaine is also a litigator. To give you a little bit of background about me, I've been with Holland & Hart for a couple of years as a partner, and my practice is 100% devoted to regulatory healthcare issues and helping my clients comply with regulations applicable to them at the federal and the state level. Some of that includes even tech companies. About a third of my clients are tech companies that are in the healthcare space and have to comply with various laws. But the rest of my clients, the 2/3, are really healthcare facilities, healthcare providers. So with that, again, thank you for joining us. We'll go ahead and get started. At the end of this presentation, we will have information again showing our email addresses, our phone numbers. We won't be addressing questions directly on this webinar today, but you can email us afterwards, or you can put your questions in the Q&A box to the right of your screen, and we will individually reach out to you and answer any questions that you may have. Of course, we always have our legal disclaimer, just trying to make sure that it's clear that we're doing this presentation to provide general information on pertinent legal topics. This is for educational purposes only, and it's not intended to create an attorney-client relationship between the participants and Holland & Hart. So with that, let's get started talking about these Utah-specific laws that anybody that's in the healthcare space needs to be aware of. The first thing that we'll cover are Utah's anti-fraud and abuse laws, and specifically talking about the Utah False Claims Act, and then talking about licensure-specific laws. Of course, this overlays anytime that we're thinking about fraud and abuse laws. You know, we start with clients issue spotting, looking at whether or not the federal anti-fraud and abuse laws are applicable, which ones would be applicable, how to make sure that our clients are compliant with those. And then we move to whichever states that they are doing business in, and looking at those state-specific laws for anti-fraud and abuse. And one, you look at some of these state statutes that, like these false claims acts or anti-kickback laws that you have in specific states, but then also you have to drill down further and look at whether or not there are licensure-specific laws. So got physicians involved, or chiropractors, or dentists, physical therapists. We want to look at and be aware of licensure-specific laws for those professions, because there are oftentimes provisions therein that will be applicable and could be triggered. So we kind of want to cover, of course, all the bases and protect our clients. So starting out with the Utah False Claims Act. Under the Utah False Claims Act, there's this anti-kickback provision that says that a person may not solicit, offer, pay, or receive a kickback or bribe in return for or to induce two different items: the purchasing, leasing, or ordering of any goods or services for which payment is or may be made in whole or in part pursuant to a medical benefit program, or the referral of an individual to another person for the furnishing of any goods or services for which payment is or may be made in whole or in part pursuant to medical benefit program. So let's talk about that a little bit. Making sure everybody understands, there are some states that have what we call an all-payer anti-kickback statute. So when we say all payer, what we're talking about is that, at the federal level, the anti-kickback statute relates to these federal healthcare programs, such as, Medicare, TRICARE, these different federal programs. At the state level, you'll either have these anti-kickback laws that are all payer or are specific to state medical benefit programs. And when we say all payer, we're referring to that these anti-kickback provisions in some states will say that regardless of who the payer is. So that could be a private payer, that could be, for example, Blue Cross Blue Shield under just, a private plan and not a Medicare replacement plan. It applies to all payers. It doesn't matter if it's a state-run program or a private insurer, they will preclude these kind of kickbacks for anybody. But Utah's is not one of these all-payer states. Under Utah's False Claims Act, a medical benefit program is defined as a benefit paid or payable to a recipient or a provider under a program administered by the state. So, very specifically, the most common one is going to be Medicaid. So just want to make sure that people are clear about that Utah's not an all-payer, but our False Claims Act anti-kickback provision refers to any funds that are paid for by the state themselves under these various programs. It should be noted that under the law, a kickback or bribe includes rebates, compensation, or any other form of remuneration that is direct or indirect, overt or covert, or in cash or in kind. However, a kickback or bribe does not include a rebate paid to the state or any state supplemental rebates. So when we get into, rebates for, let's say, different volumes and different things, sometimes these will be accepted out. But you have to really look closely at the law to understand kind of these nuances. But again, I think most of you are familiar with most of these anti-kickback laws. They're written very broadly so that it's, again, it's just not these direct payments or overt payments. These can be indirect, or it can just be any kind of remuneration or the offer to pay remuneration. And that's what's so important, is that people don't understand, well, I never received the money. We stopped it before it happened. But even if you've solicited or offered, that constitutes a violation of Utah's False Claims Act. So you need to be, very careful about that. And a violation of this this law is grounds for both criminal and civil enforcement actions. Also, under the Utah False Claims Act, it addresses claims for medical benefits. So I want to just briefly touch on this. But basically, the Utah False Claims Act is it encompasses claims that are presented, right, to the state, any of those state programs that were on the previous slide. Anybody that's submitting those claims, you've got to make sure that they are accurate, right? And so I've listed out those things which would trigger a violation of the False Claims Act for these claims being, incorrect or overtly fraudulent. So, for example, if a claim is, presented that is wholly or partially false, fictitious, or fraudulent, if it's for services which were not rendered or for items or materials which were not delivered, if it makes misrepresentations about the type, quality, or quantity of the items or services rendered, if it's representing charges at a higher rate than those charged by the provider to the general public. And that's something, that last one is something that we help clients with in terms of if you have the cash pay rate, or, what you're billing at, in general, you've got to make sure that you're not submitting claims to Utah's programs like Medicaid that are not congruent with what you generally charge others for those same services. It could also be for items or services which the person or the provider knew were not medically necessary in accordance with professionally recognized standards. And so that's an important one as well that can be a little bit of a gray area, but physicians, providers can be held accountable under the False Claims Act if you knew or should have understood that these items were not medically necessary, but you went ahead and did it anyway. So you can kind of go through and look at some of those nuances. It also includes unbundling. So most people are familiar with this term of bundling, but normally there are certain codes where it's a code that includes a lot of different items or services that are included in one, let's say, CPT code that you're going to bill out for those services. But unbundling under both these federal laws and Utah's False Claims Act, if you unbundle them and charge separately under the separate individual codes, because you could make more money when there is a bundled code, that would also violate the False Claims Act. In addition to these things that we've talked about, a person may not fail to credit the state for payments received from other sources. So for example, if you accidentally billed, Medicaid as the primary insurer, and actually they were in a secondary, for some reason in a secondary position, and then these claims were kind of reversed, and the primary insurer from a second source stepped up and paid as the primary payer, you would need to go back and reverse the claim to Medicaid and put them in the secondary position. So you've got to make sure that, if you actually receive payment, again, from another source, then you've got to credit the state for those payments that you did receive from them that you shouldn't have otherwise received. So you can kind of read through those nuances, but hopefully that helps you to understand, again, the Utah False Claims Act and what it covers. Moving next, we're going to talk about licensure-specific prohibitions. For any healthcare provider, as a general rule, I will tell you that normally there will be something that's relevant related to anti-kickback or self-referrals that will be in the particular licensing act or rule, whether that's a physician, a pharmacist, a physical therapist. If you're in the healthcare space, there will normally be something that's at least somewhat relevant. Oftentimes, if it's not called out directly, there could be an indirect call out in our Utah specific licensure act and rules. Specifically, sometimes, almost all the time in Utah's rules, it will incorporate your national, professional, ethics. So for physicians, like the AMA, right, and their rules of ethics. And so for each of these professions, normally that will be incorporated. And if you go to that secondary source and look, oftentimes, for example, there will be at least something that talks about not engaging in any financial relationships that could pose a conflict of interest, or that would cause, the provider to do something that was not in the client's best interest, but was due to a financial motivation. So you want to just be kind of aware of that. And even though in the act itself or the rule for the licensee, if you don't see like a specific call out, make sure you see if they are incorporating those national, ethical duties, and look to those specifically to make sure that's guiding, because any violation of that can then also be used by our the Utah licensing officials to bring, a disciplinary action for violation of that particular act. But specific, these specific callouts that are explicit, there are several. I'm just going to give you a few examples. So for anti-kickback provisions, for example, with dentists, Utah's laws talk about for dentist and dental hygienist, unprofessional conduct includes sharing professional fees with an unlicensed person or paying any person for sending or referring a patient. Pharmacist, it also talks about unprofessional conduct being paying or offering rebates to any healthcare provider, or receiving or soliciting rebates from any healthcare provider, or paying, offering, receiving, or soliciting compensation in the form of a commission, bonus, rebate, kickback, or split fee arrangement with any healthcare provider for the purpose of obtaining referrals. And again, there's a carve out for pharmacists here related to discounts for, volume purchasing, or passing along the pharmaceutical manufacturer's rebates. So there can be carve outs, and you have to look closely at the language as well. I would point out here that under pharmacists, it talks about healthcare providers. You have some situations where there could be some kind of referral arrangement But let's say it's for a pharmacy that is going to be, they've got a software system that they really like, and in no way is that software system, reimbursed by any insurer, like whether that's federal, state, or private. It's just software that they use in their business and they really like it. There can be situations, for example, where they want to enter into an agreement with the software provider that if they refer another pharmacy or another healthcare provider to the software provider to use that software, they say, can we get some kind of referral fee for, promoting your software? You can see that in this language for pharmacists, it's talking about healthcare provider. So sometimes, based upon the referral situation, it may not be, a kickback under our state-specific laws or federal, depending upon what the product or services that somebody's referring and the language of the statute. So you really have to look closely at those referral arrangements to make sure that it's not going to violate the law, but there can be situations that it would be acceptable, but you've just got to look very closely and have good legal counsel help you navigate that. You can see I've also included, oddly enough, hearing instrument specialists. They also include this very specific anti-kickback provision. But there are a few more, but I'm just giving you some of those examples in our Utah licensing acts and rules. Now going to disclosure of self-referrals. Again, our Utah-specific licensing acts and rules do have some specific call-outs on this disclosure of self-referrals. And I'm just giving you a couple below examples. The most prominent one is for physicians, for medical doctors, because we have a provision that says that they may not refer patients, clients, or customers to any clinical laboratory, ambulatory or surgical care facilities, or other treatment or rehabilitation services, such as physical therapy, cardiac rehabilitation, radiology services, dispensing optical lens facility, lithotripsy, in which the medical doctor or a member of the medical doctor's immediate family has any financial relationship, as that term is described in a provision of START, unless the medical doctor at the time of making the referral discloses that relationship in writing to the patient, client, or customer. That written disclosure also has to state that the patient may choose any facility or service center for purposes of having the laboratory work or treatment service performed. So that's a very specific call out under the Utah Medical Act and its rules that doesn't allow, again, physicians to refer patients to one of these outside services unless they do it in writing, unless they disclose it in writing and give the patient in writing, disclose that they have the opportunity to use any other facility that they'd like. There's something very similar for dentists, so we've included that below. But you need to be aware of those because oftentimes, even if you're not going to trigger a concern at the federal level or at Utah's False Claims Act level, you could have a concern and an issue, again, in the licensing laws and regs. And there may be ways to navigate through that, but you've got to have somebody help you closely look at that and write the appropriate disclosures. In terms of fee splitting, many Utah-specific licensure statutes and rules also address fee splitting, and I've included a few examples below. For physicians, it says that our Utah Medical Practice Act rule provides that unprofessional conduct includes directly or indirectly giving or receiving any fee, commission, rebate, or other compensation for professional services not actually and personally rendered or supervised. However, the law is very explicit that nothing in that section shall preclude legal relationships within lawful professional partnerships, corporations, or associations, or the relationship between an approved supervising physician and physician assistants, or APRNs. So to kind of give you a little bit more flavor for what that means, generally, healthcare licensees should only be receiving compensation for services they are directly performing. However, in a group practice, of course, there can be compliant compensation arrangements that comply with, let's say, the Stark Law, where, of course, the members of the group, those physicians, can get portions of of course, the revenue that's coming through that's additional. Now, under federal law, we have to navigate that very carefully to make sure that it complies with the Stark law, and make sure that the compensation agreement complies with that it is a lawful group practice under Stark, and that the compensation model complies with the requirements. But of course, physicians in a group practice should be able to get other forms of compensation. And that's okay as long as it's otherwise lawful, right, under these federal laws. Also, of course, you've got, physicians that are supervising, PAs, sometimes APRNs, and there are times when they're going to get, some kind of compensation, of course, due to how that's billed for the services of their PAs or, their mid-level providers. And of course, that's acceptable. But we just have to make sure that outside of kind of those exceptions, anytime that a physician, chiropractor, most healthcare licensees, you can't be getting compensation from, let's say it's a home healthcare provider, and the physician, is obviously not, let's say they have nothing to do with that home healthcare provider, but they can't be getting some kind of fees for services that somebody else is performing with that home healthcare, company. So you just got to be very careful about that. Moving on from kind of these anti-fraud and abuse laws, let's talk about informed consent under Utah law. Under Utah's laws, in terms of informed consent, and what we're talking about here is meaning when a patient is going to have a procedure or some type of treatment, ensuring that they understand that treatment and consent in an informed way to that treatment. Utah's law related to this comes in the context of our as a defense to malpractice actions. And under the 78B3406 of our code, if a defense to malpractice action based upon an alleged failure to obtain informed consent, the following factors that I've listed are the defenses. I'm going to skip to the bottom because the subpoint E is what most oftentimes is what you're looking at. And basically, it's a defense if the patient or the patient's representative executed a written consent which sets forth the nature and purpose of the intended healthcare, and which contains a declaration that the patient accepts the risk of substantial and serious harm, if any, in hopes of obtaining desired medical beneficial results of the healthcare, and which acknowledges that healthcare providers involved have explained the patient's condition and the proposed healthcare in a satisfactory manner, and that all questions asked about the healthcare and its attendant risk have been answered in a manner satisfactory to the patient. So we help clients all the time, right? For certain specific procedures, we help clients draft informed consents that have these elements that are listed in the subpart E of Utah statute, so that we can make sure that if there is any claim, if something goes wrong, that we have this written consent that has been signed by the patient that includes all of these relevant aspects of the subpart E. And so those are things that you want to be looking at very carefully and making sure that your informed consents for various procedures goes into some level of detail, especially about the pros and cons and the risks. If there are risks of substantial and serious harm, you've got to list those out. And then make sure that it calls out that their questions, they're representing and warranting that all their questions about the risks and about the procedure have been answered in a manner satisfactory to them. Now, there's one exception to this that, and if you've got that, it's going to be presumed that informed consent, that was met, right? So you want to do that just as much as possible in every scenario that you can possibly get it. We're going to move on to a particular unique issue regarding a bill that was passed in the last couple of years in Utah related to the pelvic region. So Utah passed a law, I don't know if some of you heard about this, but a couple of years on a national level, there were some investigative, reporting related to women that were unconscious, sedated, that were, let's say, having, some kind of, pelvic exam as part of their surgery. Let's say they were having a hysterectomy, and as part of that, let's say they would have a resident that was in the room, and the surgeon would say, go ahead and, why don't you go ahead and do a pelvic exam, on this patient so that you can get some practice. And some of these residents felt very uncomfortable, saying, well, has the patient consented to that? Do they know that for a non, let's say, medically necessary purpose, that somebody else is going to be doing a pelvic exam just to get practice? And so this kind of came out, and this is what prompted Utah legislators to bring forth this law and pass this. I think it does create some issues, but basically what this law is saying and how it was written, it says that for any procedure involving contact with the pelvic region, an additional consent form really must be completed prior to the patient receiving anesthesia or sedation. The pelvic region is defined, this is where I think it's problematic, but it's defined broadly under Utah law as the patient's sexual organs, including but not limited to the lower abdomen, vagina, labia, penis, testes, scrotum, buttocks, and anus. So with it being that broad, for example, the lower abdomen, if you think about when they're talking about, buttocks and anus, if you think about somebody going in for, just for some of their annual exams or to get their, some of these things that are done, this is incredibly broad, right? And it can be a little bit problematic. And I don't think that, it can be problematic. So what we're recommending for our clients is that if there is any, even though the patient may have signed a very specific consent form for some procedure they're going in for, that you then lay on top of it an additional consent form to make sure that you're meeting Utah law. And this additional consent form is very specific. It has to, in 18-point bold-faced type, say consent for examination of pelvic region. It needs to specify the nature and purpose of the patient examination. It needs to specifically name healthcare providers that are allowed to perform the patient examination. It needs to state whether there may be a student or resident that is authorized to either perform an additional patient examination or observe the patient examination in person or electronically. And then the law goes on to say that it needs to provide the patient with a series of checkboxes that allow the patient to consent to the patient examination for diagnosis or treatment and an additional patient examination performed by a student or resident for educational training purposes, or to consent to the patient exam only for diagnosis or treatment, or refuse to consent to the patient exam. So this one has been a little tricky and the wording is a little odd, but we've helped our hospital clients, draft these additional consents and then write policies for informed consent that make it clear what types of, what type of procedures they need to layer on this additional consent, even though, so many of these procedures, but inherently, you would think the patients understand that it's going to involve, these kind of things. But to make sure that we're just mitigating risks altogether, layering on this additional consent form, explaining to the patient why it's necessary, is really going to mitigate potential liability for healthcare providers. So wanted to make sure that you are aware of that. Going on, one of the most common questions we get is related to the corporate practice of medicine. I think, as probably most of you know, there are certain states that prohibit what we call the corporate practice of medicine. And that means that you've got let's say non-physician owners of a medical clinic. And some states don't allow that in an outright fashion. Utah, however, does not have a corporate practice of medicine statute. And if you look at the various case law and the statutes, Utah statutes allow licensed physicians, dentists, osteopathic physicians, and chiropractors to form professional corporations for the purpose of providing professional services. So of course you can create a professional entity, and a physician may be employed by a person or corporation so long as that individual or entity does not interfere with the physician's practice of medicine. So you can have non-physician owners. You can have these physicians employed by a corporation with non-physician owners. But one thing that we generally do when you have the corporate practice of medicine in Utah, specific in employment agreements of healthcare providers will put clauses that discuss that make it explicitly clear that management, the owners, are not going to interfere with the treatment decisions of that physician or that provider, and that the provider should be using their medical judgment to determine, the best treatment for the patients. And then we try and help our clients get good policies in place to back up that provision in these employment agreements. So that really helps ensure that we're being clear that the corporate entity, that management, ownership that are not physicians, that they're not interfering with the physician's practice of medicine. Now I'm going to turn to mandatory reporting requirements under Utah state law. So let's talk about that a little bit. As an example, let's say a healthcare facility terminates an employee or discovers a problem. For example, an employee has a substance abuse problem and has been diverting medication. So does that healthcare facility have a legal obligation to report? And who do they have an obligation to report to? To the National Practitioner Data Bank, to Utah's Division of Occupational and Professional Licensing, which I refer to as DOPL, and I will refer to them throughout the remainder of this presentation. How about to law enforcement? Every state has different laws related to mandatory reporting, and a lot of times this gets missed at the hospital level because they're thinking about the data bank reporting and when that's triggered, but they're not often thinking about other requirements. So let's go through that really quickly. So under Utah law, a healthcare facility, and I want to pause there and say, well, what is a healthcare facility? If you go 2/3 of the way down the slide, you'll see that a healthcare facility means general acute hospitals, specialty hospitals, home health agencies, hospices, nursing care facilities, assisted living facilities, birthing centers, ambulatory surgical facilities, small healthcare facilities, abortion clinics, facilities owned or operated by health maintenance organizations, end-stage renal disease facilities, and any other healthcare facility which the committee designates by rule. So the healthcare facility, that definition is very broad, and oftentimes I think that, for example, like home health agencies, hospice, nursing care, residential assisted facility, living facility centers, they forget this, that they've got some obligations under Utah law. So any of those kinds of healthcare facilities must report any of the following events to DOPL within 60 days after the event occurs regarding a licensed healthcare provider. I've listed these out for you. I'm just going to name a few, but if you terminate an employment of an employee for cause related to the employee's practice as a licensed healthcare provider. So if you feel like they're not doing a good job as a nurse, as a physician, and you've terminate them for cause due to how they're practicing their profession, this would be triggered. If you terminate or restrict privileges for cause, so if we're talking about a hospital, a surgical center, you've got physicians, right, that have privileges. If you terminate or restrict those for a specific reason because there's a concern, this would be triggered. If you terminate, suspend, or restrict membership or privileges for acts of unprofessional, unlawful, incompetent, or negligent conduct related to practice as a licensed healthcare provider. I'm going to skip some of these, but some of these are a little ambiguous, and this is where it gets a little tricky, such as look at the one about a finding that a licensed healthcare provider has violated professional standards or ethics. That's really, a little bit vague, and I'll often get calls from clients, and we have to look at the fact pattern involved and look at the professional standards and determine whether or not we've met that threshold here. And the last one is the one that I think most commonly, I would say, probably happens. It's a finding that a licensed healthcare provider is engaged in abuse of alcohol or drugs. So if you find out that a nurse or a physician in your organization or any healthcare licensee has been engaged in the abuse of alcohol or drugs, let's say that you find out that they've diverted a medication, this law is likely going to be triggered. And I want to emphasize at the bottom, when you look at who constitutes a licensed healthcare professional or healthcare provider, that is any provider licensed by DOPL that is, a healthcare in the healthcare field. So I've listed out some of those, but it's a very long list. So oftentimes in facilities, their eye is on physicians, maybe, nurses, but it's not often on all these other people, people that are clinical lab technologists, pharmacists, physical therapists, respiratory therapists, psychologists, audiologists, clinical social worker. I mean, this list is long. And if any of these things happen, you need to think about whether or not there has been triggered a duty to report to DOPL about these concerns. Next, I want to talk about a law that was passed a couple of years ago in Utah regarding diversion specifically. So Utah law now holds that an individual is guilty of a Class B misdemeanor if they know that a practitioner is diverting 500 milligrams or 500 or more morphine milligram equivalents to another person for an unlawful purpose and fail to report to law enforcement. So this has created some serious concern because this makes it, again, a crime, a Class B misdemeanor, if you know of this and you fail to report to law enforcement. And if you look at how the bill defines practitioner, it's an individual who's either allowed to administer, dispense, distribute, or prescribe a drug in the course of their professional practice, or who's employed by such an individual. So anybody that, again, can prescribe, administer, dispense. So you got to be thinking about physicians, pharmacists, nurses, but then also who is employed or somebody who's employed by those individuals. So they might not meet the requirement for, that subpart I or one, but under 2 they would. So the law broadly applies to those licensees involved in providing medications to patients in any manner, and as well those employed by such individuals. I will point out that this law does not apply if the individual is precluded from reporting under HIPAA or 42 CFR Part 2, which relates to records of an alcohol or drug abuse treatment center. So there is a carve out for that, which is appropriate, obviously. This law is fairly new and it's yet to be interpreted. There is no case law on this. But what's interesting to me, and I guess if I were to counsel the Utah legislature in terms of what they were trying, what their purpose was with this law, what's interesting is this language about diverting to another person for an unlawful purpose. I would argue that most of the time when people are diverting medication, it's because they have an addiction issue themselves and they're not diverting it to another person. So this may or may not be triggered depending upon the facts, but it's one of those things that you need to have your legal counsel carefully look at the circumstances and decide whether or not reporting is required. And you need to be aware that in those circumstances where it is required, it could now be a crime for failing to do so. I'm not going to get into National Data Bank reporting because this is supposed to be a webinar specific to Utah law. But I just want to point out, don't forget about data bank reporting. Most of you are very well of what that means, but I have listed a couple of slides to just refresh your memory about when that is required. I've included a link to the data bank guidebook, which is a great resource and really goes through in very simple layman's terms to help entities understand when they have an obligation to report and how to go about doing that, and answers a lot of questions. So be sure to use that to provide some guidance and assistance. And just note that there are sanctions for failing to report to the National Practitioner Data Bank. You can lose your immunity protections for 3 years. and HHS may instigate an investigation. I will note that I think it's normal in institutions like hospitals for there to be data bank reporting. There should be, right? If everybody's doing their job, there are a lot of scenarios that require a data bank report. And I think if, you know, on the whole, I think if HHS, you know, looks and is doing an audit and you're just not seeing any reporting from facilities, I think that alone would trigger like a red flag for HHS that there's not proper reporting going on, and that could be problematic. So I don't think you want to be the outlier there. You need to be reporting as required under federal law. So I did just put like a reporting decision tree here, trying to help individuals kind of visualize the reporting requirements. But if there is an adverse event, you know, an adverse action that's being taken involving an employee or a member of the medical staff in one of these healthcare facilities, these are the questions you should always ask yourself. Does it trigger mandatory reporting to the National Practitioner Data Bank? If so, you've got to do that within 30 days. But you should know, and on the prior slide I mentioned it, if you fail to report timely, that doesn't excuse, you know, you still have to report, and that's okay. So even if you forget to do it, your legal obligation to report still exists, even if you fail to do it within the first 30 days. You've got to go back and do it. And sometimes I've had to help hospitals do that when it was, you know, should have been done 6 months prior. So just keep that in mind. Now, always ask yourself, does this trigger a report to DOPL? If so, it's required within 60 days. And does this trigger a report to law enforcement? Under that law, there's no specific time frame, but of course you should do it timely, probably commensurate when you're doing some of these other reports. Next, I wanted to cover one of the most common questions I get, especially from hospitals, relates to medical decision-making of incapacitated adults under Utah law. So I just want to cover this briefly and walk you through this under Utah law. So of course, healthcare providers are generally required to have an adult patient's consent before they can administer any type of medical care. And under Utah's laws, an adult is presumed to have the capacity to make their healthcare decisions, and I'll refer to that as capacity, when they can understand the nature, extent, or probable consequences of health status and alternatives, make a rational evaluation of the burdens, risks, benefits, and alternatives of accepting or rejecting healthcare, and communicate a decision. So this often gets overlooked. When somebody to overcome that presumption that a patient has capacity, Utah law specifically says what must be done. And that's that a physician, APRN, or PA who has personally examined the adult patient must find that the patient lacks capacity. And again, those are those three, you know, subparts that we just talked about in the last slide. Record the finding in the patient's medical chart and indicate whether the patient is likely to regain capacity, and then make a reasonable effort to communicate that determination to the patient, other healthcare providers or healthcare facilities that you would likely need to notify, and any known surrogate decision maker. So an agent, guardian, or default surrogate decision maker. Oftentimes that doesn't happen explicitly, but I want to point out that under Utah law, that's what you need to document in the patient's chart. So moving on, when a patient, there's this finding that the patient lacks capacity, now it's who gets to make decisions for this patient. The highest priority is going to be a legal agent formally designated by the patient. So let's say the patient gave somebody medical power of attorney should they ever be incapacitated. That would be the highest ranking default decision maker. Next, it would be a court appointed legal guardian. So let's say a patient has, you know, Alzheimer's or, you know, has some kind of disability and they've been appointed a legal guardian because of that. That would be the next in line. Now, sometimes people will have both a legal agent and a legal guardian, and they could be different. And under the law, that legal agent will have priority over the legal guardian. But what happens when the patient does not have either? Utah law goes through and says, here's how you decide who has the authority to make decisions on behalf of this incapacitated patient. and it goes in order of priority. So the patient's spouse, unless they're divorced or legally separated, a child, a parent, a sibling, a grandchild, or a grandparent. Now, there are nuances in this. You know, what happens, let's say there's no spouse and there are 5 children and they are disagreeing about what should happen. Utah's law talks about the majority, it should be the majority decision, but these surrogate decision makers are supposed to make decisions in conformity with the known wishes of the patient. And sometimes there just gets to be some really nuanced issues that play out here. And that's when I get calls from my hospitals saying, help us through this and make sure that we're doing this right according to Utah law. But what if the patient doesn't have any of the above? Now, I will tell you that the last, after a grandparent, the law does say in Utah that any person that's over the age of 18, let's see, and this wasn't in here, but anybody that's over the age of 18 that has capacity themselves and has not been disqualified by the adult individual themselves or a court, if they, you know, have a special relationship, like a friend, they're just a friend of the patient, and they are willing, they could step in and act as that surrogate decision maker. So, you know, an adult friend could act in that role if there's nobody else in priority above them that's willing to act on the patient's behalf. But you always have to go in order of priority and prioritize these individuals. So if there's a patient spouse and their children, the children want one thing, the spouse wants another, you have to go with the highest priority decision maker. But what if there's none of the above? Sorry that I keep going back and forth on there. One thing I wanted to mention is that some states have particular explicit statutes regarding what needs to happen when there aren't any of these individuals, these relatives, and there's no, you know, patient or no friend that's, you know, 18 years old or willing to step in. So some states have in their statute, they say, for example, that it could be, if it's a hospital, it could be, you could involve like the chaplain, and based upon the treating provider, what they're recommending, then the chaplain could look at this and you know, confer and be this default surrogate decision maker. Some laws say that it goes through the ethics council of the institution, and that decision of the ethics committee is what they can act as a surrogate decision maker. Some talk about having 2 physicians that are not the treating provider look at the case and confirm whether or not the action that the treating provider wants to take, if that is the appropriate action to take. And then that is what happens. Utah's law is completely silent on this point. And sadly enough, this does happen quite a bit in the hospitals, where you have somebody that is homeless or has been living alone for years and years, is estranged from their family. You've got social workers trying to track down anybody, and they cannot find anybody to act on behalf of the patient. And so we get those calls, and it's a little tricky because Utah's law is silent, but generally we, you know, have the hospitals create a policy where they're following one of these, you know, very kind of safe procedures that other states by statute have instituted. And as long as they're doing that in a kind of consistent manner, it should mitigate the risks, since there is nobody available to be the default surrogate decision maker in those situations. Quickly, I want to just touch on minors' ability to consent to medical treatment under Utah law. So this is another question I get quite a bit as well. So for purposes of consenting to their own general medical care, the following minors are treated as adults under Utah law: legally emancipated minors, those in active military service, unaccompanied homeless minors 15 years of age or older, and minors who are lawfully married. Additionally, a parent or legal guardian can always permit their child to consent to their own care by executing a written authorization that allows the minor to have a confidential relationship with the provider and consent to their own treatment. So sometimes you'll see this in situations of counseling, you know, mental health therapy, where the parent knows that the child's struggling and the child doesn't feel comfortable, let's say, opening up to the provider. And the parent says, look, I just want my child to be okay. Let me just give you authorization that my child can have this confidential relationship with you and they can consent to their own treatment because I want to make sure that they get the help that they need. That's one example. Sometimes when you've got, let's say, a 17-year-old that's almost 18, but let's say they're going in for allergy shots and they have to do that, you know, once or twice a week, and they're driving themselves. Normally you need to have a parent there to consent. Oftentimes in just situations like that where you've got somebody that's older, the parents already consented to the overall general care, and the patient can drive themselves. Sometimes you'll see the provider asking the parent to sign some kind of authorization that allows the patient, this minor, to get that care on an ongoing basis without needing the parent present. Additionally, a handful of Utah statutes provide minors with the authority to consent to their own care for specific types of medical treatment. Specifically, any minor who is or professes to be afflicted with a sexually transmitted disease can consent to examination and treatment for the STD. Any minor female who is pregnant can consent to medical services related to her pregnancy or childbirth. And then you've got a couple of, other things as well. So be sure to read those carefully. I will say that when it comes to the STD, sometimes, we get questions about this, somebody wanting to get, birth control. There are kind of carve outs, obviously, under federal law for when minors can do that at clinics that are funded under federal programs, such as, Planned Parenthood is one of the most common ones where these minors can get treatment or get counseling regarding birth control without parents being involved. But outside of that, it's tough when a minor presents and wants to go see, let's say, their primary care physician and wants to talk about, birth control. Under Utah law, there is no exception for that, where under some state laws, there is an explicit exception, for that with minors that are, kind of a certain, mental state and maturity, that they can consent to their own care and treatment. Utah does not have that explicit law, but if a minor is concerned about an STD, that is a carve out. So that's it for the Utah specific laws. We've only got 8 minutes left, but I am going to turn the time over to Blaine Bernard, who's going to cover the 2021 Utah legislative session has a lot of healthcare related bills that are pending. So we want to make you aware of those so you can at least track those and be aware of those because of course some of those will get enacted and you'll want to be aware of those. Thanks everybody.
Thanks, Christy, for that overview. Those obviously are some of the key regulatory compliance issues specific to Utah. As you can tell, Christy has a great handle on these issues and tremendous expertise and can be a great resource to everybody. We could take many of those different sections and talk about them all day long. But it's good to keep in mind that, we have the federal regulatory scheme as well as this Utah scheme that we all have to make sure we're complying with and are knowledgeable about. So quickly, with respect to what's going on at the Utah legislature now, they're in session. They end on March 5th. There are, as you can see on the slide, 33 pending or already passed healthcare related bills. Some are already passed, some have been sent to the governor already for signature. There are 8 more bills that we expect to come out of committee in the last 8 days of the legislature. There is 1 or 2 others, one of which is very significant, but we're hoping that it won't ever even make it out of the bill writing process. But our firm and our lobbyists, as well as lobbyists for some of the associations, are trying to kill another bill before it becomes a bill. So that's sort of the what's going on. There's 2 joint resolutions, and Luke, can you go to the next slide? So the top areas for this year, there are 5 bills that deal with mental health issues, 5 that deal with pharmacy regulations, including some significant changes in the Pharmacy Act. There are 4 that deal with vaccination and immunization, which shouldn't be surprising given the current pandemic that we're in. There are 4 interesting bills that direct the Utah Department of Health to seek additional federal funding for Medicaid programs. This is where the legislature is saying, hey, Department of Health, we want you to go and get some more of this federal funding that's available for our Medicaid program. And those 4 bills have to do with contraception for family planning for low-income individuals. There's another direction to extend family planning services to low-income individuals. There is one to fund coverage for postpartum care for low-income mothers. And the last one is to provide funding for medical respite care for homeless individuals. So those are areas where the legislature is directing the Department of Health to go obtain more funding and develop these programs further. The legislature has created 3 new government councils or task forces. These deal with mental health issues and crisis management issues. There are 3 medical cannabis bills, one of which includes a major rewrite of the legislation that was passed last year. And then there's 2 regarding telehealth. That's not all of them. Those are kind of the top areas of healthcare that are being addressed by the legislature this session. Luke, go ahead and switch to the next slide. So this is a list of them, and just be mindful. At the end of this, you will all receive an email with a link to this slide deck. So if you want to look at specifically some of the names of these bills and their number, you can do that when you get the link to this slide deck. Go ahead and go to the next slide, Luke. Now, just so you know, also most of the healthcare associations monitor the session closely and become involved in lobbying efforts. We often work closely with them, like the Utah Hospital Association, the Utah Healthcare Association, the Utah Medical Association, the Pharmacy Association, all those Nurses Association, all those major associations. Some of them have specific lobbyists that are employed by them. Some of them employ private lobbyists, but for the most part, particularly, large system hospitals, they usually have their own lobbyists who keep a close eye on these things with us. I think with the 3 minutes we've got left, let me just talk about this one, because this actually was a bill and law that was passed last year as COVID was just coming into its own in April of last year. On April 22nd, the legislature passed this immunity bill, which was signed into law and became effective in August of last year. And the legislature, while they were in session, were heavily lobbied by healthcare providers to provide some sort of additional protection to providers, given the pandemic and the rapid spread of the disease or of COVID. And so this is really the guts of the statute. It says a person, and a person is defined to include healthcare providers, corporations, hospitals, long-term care facilities, individual providers, and so forth. A person is immune from civil liability for damages or an injury resulting from exposure of an individual to COVID-19 on the premises owned or operated by the person, or during an activity managed by the person. So this really became important for hospitals, nursing facilities, and so forth, to provide added protection and comfort that they weren't going to face, an onslaught of lawsuits if a person contracted the virus in their facility, or if a person died after contracting the virus. And so this will yet be tested in the courts, but it's something that most states have passed a similar statute. Now, obviously, it does not apply to willful misconduct reckless infliction of harm or intentional infliction of harm. But, you know, the typical sort of negligence claim, an accident type claim, or, you know, things just happen in hospitals and healthcare facilities, those types of claims are the ones where we're going to provide, the state's going to provide this sort of protection and immunity. I don't have time. I pulled 4 or 5 other statutes or bills that were quite interesting. Let me just finish like this. You know, as these start coming out of the legislature and getting signed by the governor, it's always good to make note of the new changes. There are some that are interesting related to vaccination reporting, the provision of electronic medical records to patients upon request. There's a new, they renamed the Life with Dignity Order form. It's now called, you may see it because the state has put it out already on its website. It's now called the Provider Order for Life-Sustaining Treatment, or POLST. And it's interesting because now, and this one's already been signed into law, it allows for electronic signatures. You no longer have to have a wet signature from the patient. It also allows for verbal confirmations to satisfy the requirements of a signature in certain situations where it's difficult to obtain a written signature. So anyway, there's a lot of them that are worth looking at, and we will probably do a legislative update a few weeks after the session ends, where we can talk in more detail about some of these that will apply to your facilities and your the way you provide healthcare services to people in Utah. And with that, let me again just remind you, you'll get a link that is to this slide deck, but also a link to our Holland & Hart's healthcare blog. You can see the reference to it right there on that screen now. And this blog, as some of you know, is full of resources. It has recordings of prior webinars, has update on cutting edge changes of the law and so forth. And so you're all welcome to view that blog and take advantage of all the resources that are on that. And let me just maybe point out one more thing, because we've seen this a lot lately with a bunch of providers who are receiving self-audit notices from either the state treasurer's office or from its vendor, which is called Veris Analytics. It basically has to do with the Unclaimed Property Act in Utah. So a lot of providers are receiving these notices and don't know what to make of them. And then they're getting a notice from this company out of New Jersey. So anyway, just be mindful, it's legit. You can look at the Unclaimed Property Statute in Utah and figure out what your obligations are. We've dealt with both the treasurer's office and this third-party vendor that it's hired. But with that, good luck with everything. We appreciate your attendance. We appreciate those of you who we have the chance to work with closely. And with that, I will sign off.